Welcome to Infringe at Your Own Risk.
Welcome back to Infringe at Your Own Risk with Randall Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups all the way up to international companies. My name is Kevin Rosenquist. Today we're talking about trade secrets. What are they? How can you protect them? And why they are as valuable as a patent. Rand, good to see you. Welcome back.
Thank you. Good to be back.
So we're talking trade secrets today. Always a very interesting topic because it's a little different than patents or things like that. So let's start here. What technically qualifies as a trade secret?
So a trade secret is really much broader than people think. They typically think of, the Coca-Cola formula or AFC's original spices and whatnot. Something super high tech. And a lot of times the most valuable trade secrets aren't that. So a trade secret, number one, it's got to be a secret. Number two, the owner has to have taken reasonable steps to maintain its secrecy. And number three, it has to have economic value. Okay, so the one thing that most people don't think of as a potential trade secret is their customer list. If you're a company and you're, it would be advantageous for someone to know who all your customers are because it's going to be a lot easier to compete with you. Often that is the soon-to-be former employee that is your biggest threat. Because if they've got a copy of your customer list, they know who the customers are. They probably know the buying cycle. They know what your price points are, and then they can get there and, just before they're ready to buy from you, they come in lower price, whatever to try and steal that business away. So, question number one is the information you're trying to protect secret or confidential, right? I mean, it doesn't have to be super secret. It just has to be generally not known in the public.
Mm-hmm.
And then the second step, and this is where most companies, in particular small companies, right, is you've got to show that you took reasonable steps to maintain that secret. So if it is your customer list, is it sitting on your desk? Is it, locked away somewhere? Is it segmented, right? So your salesman who covers the state of Idaho, right? He needs those customer lists. He doesn't need the one for Mississippi, but does he have access to every? Well, that you're putting yourself at risk multiple ways. Even if it wasn't a trade secret, you're just giving out the information. But as part of the process, a judge or jury is going to look and say, did they take reasonable steps to maintain this secret? One of the things that a lot of franchises will do is they will mix ingredients and send them to their franchisees. So the franchisees don't know what the recipe is for the secret sauce. That makes a franchise popular, right? I love Chick-fil-A sauce on it. Well, they probably, the individual franchisees don't know what the formulation is. The company does. And in doing that, they're keeping control of that secret. And then people have to try and figure out how to recreate that. So it's just, if you've got something that's confidential, put it as a need to know, only give it the information to a small group of people who need it. Have non-disclosure agreements and things like that in place to help control that. And then if you ever have to go to court, you can say, here's our information. It was confidential or secret. We did X, Y, and Z to maintain its secrecy, and it has economic value to us because people love our secret sauce and they come in for it. I mean, I had a client who had a hot dog business and it's done very well. And part of what is that he had a really great sauce that he put on the hot dogs, right? Nobody else knew the formulation but him. So the bad thing of that is if you die, you have a problem. So you need to make sure it's written somewhere. But, at Coca-Cola, there's a very small number of people who know the actual formulation for Coca-Cola. That's limited people at KFC who know the actual formula for KFC. So that's what qualifies as a trade secret.
I'm curious, just as a side, like you gave that example of the customer list, say, and a former or a soon to be former employee grabs it. Like, first of all, how do they generally know that someone stole it? And number two, what's the punishment for that generally?
How you know that someone stole it, it's hard to know
Mm-hmm.
unless you can get like their formula and figure it out. But part of the reason you keep something a trade secret is it's not easily reproducible. Right. So, for example, if you have something that can easily be read by a mass spectrometer, your formulation's not going to be all that secret because I just need to stick it in the machine. Oh, here's all the ingredients and I can go make it.
Right.
But
Yeah.
a good trade secret is something that's hard to reproduce like that. Now, the flip side of that is it's hard to find direct evidence usually that someone has stolen your trade secret. Sometimes you have to do it with evidence that's more circumstantial, right? We are making our product this way. The competitor made it a different way, and then all of a sudden they switched, right? And their product looks just like ours now, and things like that. And our VP of engineering left and went to their
company.
right? And
Yeah.
you get a basis, and then you can start going in and seeing what changes, and you can do discovery and all of that. But it can be a challenge to figure out, what it is. Now,
Yeah.
what's the remedy? Often the remedy is just economic damages, and that can be your lost profits and their profits. But there are situations where it's actually criminal, and people have been prosecuted and sent to jail for theft of trade secrets.
Wow.
So,
Okay. Interesting.
Some people served a long time in jail. Yeah, not worth it.
No, I would say not. So you went over what a trade secret is and what qualifies as a trade secret. So how are they different from patents or copyrights as far as how one goes about getting them, as far as how long they last, etc.? What are the differences there?
Okay, so a trade secret you get by simply keeping it secret. Right? You don't file a form with the government. You don't do anything like that. You just follow those steps of maintaining the secrecy. A patent, you have to file it with the Patent and Trademark Office. And under the Constitution, the theory behind patents is, I invented something. I'm going to tell the world what I invented, and I get exclusive rights to that invention for a limited number of years in exchange for telling the world what I invent. Right. So then the whole world can know what I've done, and they can go out and reproduce it once my patent expires. A trade secret is just the opposite, right? I'm not telling the world about it. And so I'm protected from non-disclosure. But if somebody else creates the same thing, they invent it, they stumble into it, I don't have any recourse. As long as it went out without any improper conduct. It's public domain, and I can't, put the cat back in the bag. So that's the difference between patents and a trade secret. Copyrights is kind of similar to patents in that there's a disclosure to the public. Right? You submit here's what I want copyright into the patent and trade or to the Copyright Office, and the Copyright Office says, all right, here's your registration number, and you have this long period of time where you're the only person that can reproduce that work. Usually copyrights are different subject matter than trade secrets because copyrights protect expression as opposed to patents, which, protect like an invention or a utilitarian model. The one place where copyrights and trade secrets can overlap is in software. The coding that you use to write the software, well, you can have parts of your code that are done to reproduce certain things very easily for you. And that coding may be a trade secret to your company. And there are provisions within the copyright laws that you can actually redact certain parts of copyright code to get a registration in the copyright and maintain some information as a secret. So
Okay.
they're very different. And copyright infringement is I copied your expression, whereas trade secret infringement is I improperly got the information and I used your trade secret.
Right. Okay. Okay. And what steps do you recommend businesses take to protect those trade secrets?
First, I would consult with your attorney, get an idea of what is protectable, what's not. I mean, sometimes people think that they've discovered something that's really amazing, and it turns out lots of people in the industry are already doing it, so that doesn't help you much. So first, consult with your attorney. Second, you need to sit down and say, what information do we have that gives us an economic advantage, which is not generally known to our competitors? That helps you break down, this is the information that we think is potentially trade secret. Then the next step is, okay, now what are we doing to protect it? Right? Is it kept in the safe? Is it on the server but with restricted access? Is it sitting on top of my desk where everybody who walks in the office sees it? And it's happened. I mean, I've seen cases where, that really was confidential information. And then the other side submits multiple declarations that, they just left this paper all around the company. You could find it on, the president's desk, his secretary's desk. It was in the shop.
The recipe was written on a whiteboard in the conference room.
Exactly. That wasn't erased before the next 5 meetings. Yeah, then it's kind of hard to argue that it's trade secret, but it happened more than you would think.
Yeah. That's funny. So when it comes to the employee side of things, are NDAs, how do they fit into trade secret protection? Is that something that's commonly used?
Yes. NDAs are very important if you have confidential information to keep your information from going with employees when they leave. And it's even more important. A lot of people for years have used non-compete agreements with people to say, okay, well, you can't work in the same industry, so my stuff's somewhat protected. A lot of states are striking those down now and not allowing them. The FTC passed rules to ban them, and then that last I heard that was overturned by the courts, but that could change. But those are used to control people misusing the information. But a non-disclosure agreement is still under even the states that have banned NDA or banned non-competes. You can still use a non-disclosure agreement. And the biggest thing about the non-disclosure agreement is it reinforces to that person, you have obligations to this company. Even when you leave, you need to maintain this information confidential and not disclose it to other people. And, some people, when you leave, they remind you, they send you a copy of the NDA that you signed. If you're going to have NDAs, though, one of the important things is have people sign them. You wouldn't believe how many cases I've been involved in where, this guy's got an NDA, and then you get into court and nobody can find the one he signed. That's like, well, you have a lot of NDAs, but not with him. So, or with her. So you make sure that you've got a good organizational setup for when you onboard somebody. If they're going to be in an area where they need an NDA, they sign it and you have it in your files. So that if you ever need to enforce it, you have it to enforce.
Yeah, for sure. That's kind of funny. On a side note, I'm kind of glad they're getting rid of these non-competes, just because I've worked in industries where I've had to do that, and it's always just felt a little unfair to me, especially if you're very niche in what you do. That it kind of really limits you if you get laid off, if you just want to better yourself or something like that. Total side note, but I've always kind of disliked those.
They can be abused. I think they have been abused. That's why there's so much hostility towards them. The guy who's working on the dock making $15 an hour probably doesn't need a non-compete, right? I mean, you load a truck the same way in most parts of the industry. I can see their place if somebody is very high up in the company, like the head of R&D, a president of a company, and say, you're in this field, you're getting all this highly confidential information. I don't want you going over and being with my direct competitor because as much as I can lock away my trade secrets, an awful lot of them are in your head, and you know that
Sure.
information. And so
Yeah.
I think there's a place for them, but they just got abused. And so that's why there's so much sentiment against them. I think if they were very tailored, the one place where they still stand up is if you sell a business, most courts will enforce a non-compete. If you sell your company, because they don't want you selling your company and then next week opening up a competing company across the street.
Like the same thing, and
Brand,
with a different name.
brand
Yeah.
new, funded by your competitor.
Yep. Yeah, that does make sense, and I understand the spirit of it, but always feel like it trickled down probably too far to industries and levels where it's like just not necessary.
Yes.
Yeah,
The janitor
totally.
does not need
Yeah.
or a non-compete.
You can't work at any other place. When might it make more sense to keep something as a trade secret versus a patent? How do you kind of coach your clients as far as which one makes more sense for them?
Okay, so the biggest factors for maintaining something as a trade secret. Number one, is it protectable as a secret? Right? If it's easy to reproduce, if people can figure out what you've done, right? If you're etching a piece of metal with an acid, but people in the industry can look and say, you know what? I'll bet they're etching that piece of metal with this type of acid.
Mm-hmm.
Then it's not a very good candidate for a trade secret because it can be easily reverse engineered. Okay, so question one, can you easily reverse engineer what you're doing? If yes, then trade secret's not a great idea. If no, then a trade secret may be a good idea. The second factor is, how likely is this to be patentable? Because sometimes a trade secret can be something fairly narrow, right? I mean, let's go back to the acid example. I'm etching this piece of metal with sulfuric acid. Okay. Everybody else is using some close chemical to sulfuric acid, but it's different, just slightly different, but it creates a different effect, right? That they wouldn't appreciate what I'm getting out of it. Sometimes those are really hard to get a patent on because the patent examiner says, well, you're using sulfuric acid and they're using this other acid, which is really similar. So it would be obvious. And so you don't get a patent on it, but now it's out there. I mean, you can file it non-disclosure, but it's still a risk. And so the second question is it likely I'm going to be able to get a patent on it, or does the patent office, are they just going to think this is a patent, or this is obvious in light of what's done? And sometimes you'll get something that's, one chemical within a range that's well known, right? People know that you use this range of chemicals in something, but you find out that if you use this particular one, you get a 20% better result. Okay, that may be hard to get a patent on. Sometimes you can, sometimes you can't. But if people can't figure out you're using the other chemical, it may be something you just want to protect as a trade secret. And then you're getting that advantage in the marketplace without the risk of disclosure going through the patent office and all that.
If a business owner thinks that their trade secret has been compromised, what's the first step they should take?
Hire an investigator to come in and look and figure out where it would have been compromised. I mean, sometimes
Yeah.
If 3 people leave your company and go start a competing company, okay, you kind of know where that chain goes. It's a lot harder if, company X, your competitor, suddenly starts doing what you're doing. Because they could have invented it themselves, or you could have somebody in your company selling information out the back door. And then you need to kind of discover that. And sometimes people file lawsuits over that. It's like, well, we know you're using something very similar to ours. We're going to use the discovery process to try and determine that. And it's a challenge.
Yeah. Expensive too, I'd imagine.
Yeah. The same reason that a trade secret can work makes them hard to discover if they're violated.
Yeah, that makes sense. All right. Well, thanks for listening to today's episode of Infringe at Your Own Risk. To learn more about protecting your company's trade secrets, visit batemanip.com. And don't forget to subscribe to our channel. Leave us a review. We very much appreciate it. Rand, always great chatting with you. Thanks so much for being here.
Thank you. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.